and trade secrets. And in the time that we've got, I'm going to talk about the first three: trademarks, copyrights, and moral rights. And the first one I'm going to talk about is trademarks. Now, you've seen this on when you buy a can of soda, or I'm looking at this bottle of water that I've got. This bottle of water has a little circle R, like it's on the screen. That means it is a registered trademark. Now, what trademarks do is they identify the source of the goods, they identify the quality of the goods, and trademarks that are involved in things like services like Jiffy Lube or things that are not specific goods, they're called service marks. Trademarks are governed by a law called the Lanham Act, and trademarks could be abolished if Congress wanted to do it. Patents and copyrights are part of the Constitution. Trademarks are not. And trademarks go all the way back to medieval guilds, and this is the way you could tell how good the bowl you got was, the pottery you got, the tool that you may have gotten from the Ironmongers Guild or the Silversmiths Guild or the Pottery Guild. They put a mark identifying where the guild was, and you could tell if it was a master crafts person as opposed to an apprentice, as opposed to a journey person. Now, trademarks are always involved in commerce. Trademarks involve something being bought and sold, a good or a service. And they generate feelings which is why the companies that own trademarks protect them so much. I'm going to show you a few trademarks that are as barren as possible, and you're going to immediately recognize them. So, this trademark. Is there anybody who doesn't recognize what this trademark is? The trademark of the Walt Disney Company, obviously. This is Mickey Mouse. And what do you feel when you see Mickey Mouse? Do you feel warm? Do you feel, remember your childhood? Do you think exploitation of children? But you recognize it immediately, and you have impressions from it. Is this really going to? I'm getting a note that my meeting is going to end in 10 minutes. Is that going to? You're going to take it? Okay, thank you.
Why don't you escape from the Zoom and we'll just use it?
Here we go.
Oh, there.
Okay, you see a trademark like this one. Again, is there anybody who does not recognize the swoosh? And so, what do you think of when you see the swoosh? Do you think of sports? Do you think of Michael Jordan? Do you think of poor children in China having to work at sweatshops to make T-shirts? Doesn't matter, but you recognize it, and immediately you have an impression of it. And this one, obviously, again, as bare as can be, but you immediately recognize it as McDonald's. And again, you see McDonald's, and you say, I know, I have feelings that come from looking at this. There are people who are afraid to test out new food when they travel. But they see this trademark, and they say, okay, I know what I'm going to get, and so I'm comfortable going there. When we look at something like this, it sets up attention. We say something is wrong with these pictures, because the trademarks are so strong that when we see them jumbled like this, we say something's the matter. But all of this shows how important trademarks are, how important logos are, because we know what to expect. And why they're protected so much is if you go to a flea market and you buy a T-shirt that you think is a Nike T-shirt because it's got the swoosh on it, and then you go home and the first time you wash it, the color is run and it starts to fray. you suddenly think, I don't like Nike anymore because its quality is no good. So these trademarks convey a certain level of quality, certain level of the source of the goods that these companies want to protect very much. Basic to trademark law. Trademarks have to be registered. If any of you ever are trying to do a logo, you do have to register it with the Patent and Trademark Office. It requires a lawyer. Unlike copyrights, you really need somebody who's a specialist in this stuff. And trademarks have to be used in commerce. Trademarks involve business, buying and selling goods, buying and selling services. So to have a trademark, you have to be expecting at some point to sell it. Trademarks have to be distinctive and not descriptive. What does that mean? It means that if you're selling red apples, you can't trademark the name Red Apples, because all that trademark is doing is describing what you're selling. If you're Apple Computer, though, you can trademark Apple Computer because the computer has nothing to do with those red apples. So if you're a company, you can trademark apples. If you're not a company, if you're selling apples, you can't. If you're selling orange juice, you can't trademark the word orange juice. When you look at this bottle of water that I've been given, the trademark is for the name that's called Abso-Pure, because Abso-Pure could be anything. Underneath it, it says natural spring water. And they can't trademark natural spring water because that's just descriptive. Can colors be trademarked? And the answer is, it depends. In the United States Trademark and Patent Office has said that Louboutin shoes can trademark the red soles. And so nobody else, no other shoemaker in the United States can use red soles on their shoes. The European Union Trademark Office said the exact opposite thing. They said that you could not trademark that color combination. Tiffany blue can be trademarked. What about infringement? Infringement is somebody stealing a trademark, copying a trademark. The test for trademark infringement is confusion. Is a consumer confused if they see a similar looking article? And how do you test that? Well, you know what you might do. There was a case involving caramel candies. Caramel candies that had a certain type of wrapper, a certain type of lettering on it, and you have a survey, for instance, and you show people these two T-shirts, and you say, who do you think, or these two candies, say, who do you think made these? And if they can't tell the difference, then that is trademark infringement. Now, what about parody? You know, we as artists, we can make fun of trademarks. We can do things with them. This is, somebody did this, this is called From Sky Pirates. And as you can imagine, the Disney company was not amused by this. And Disney won this case. On the other hand, this is Wally Wood's Disney Memorial Orgy. In this situation, Disney lost this trademark case. And the court said this is clearly parody. Nobody looking at this would think that the Disney company had really done this. So it's hard to tell. It's hard to tell. You take your chances. I have a practical rule about this. And this is not a legal rule, it's a practical rule. If you are deciding you're going to do a parody of a trademark, how much money are you putting in to do this? Because if you do it and the company that owns the trademark doesn't like it, they're not going to sue you right off the bat. They're going to send you this nasty letter called a cease and desist letter saying, stop it, you're infringing our trademark. And then you have to decide, are you willing to fight it, or if you've not put that much money in it, you stop it. So you make a practical decision. I want to show you another couple of cases about this. An artist named Tom Forsythe took a bunch of Barbie dolls and put them in different situations. This one I think is enchilada Barbie. This was Barbie on the half shell. This was oyster Barbie. This was margarita Barbie. This was half moon Barbie. This was stir fry Barbie, mix master Barbie, and Barbie in a blender, and slow cooker Barbie. The Mattel company was not very amused by this. And the Mattel company sued Tom Forsythe, and they were in court for several years. The court ended up ruling in favor of the artist, and they were so angry that Mattel had gone out of its way to the courts to persecute this artist, who ended up getting legal work from the ACLU and a couple other places, that the court awarded over $2 million to the artist to be paid for by Mattel, to pay the lawyers, and also to pay for what the court said was just this frivolous lawsuit. Now, what about house brands? Is that trademark infringement? You look at something like Pepto-Bismol. Colors trademark, very distinctive lettering, very distinctive shape. Now all these other drug chains, getting that my free meeting is ended. Okay, thank you. You have Bismutrol, same colors, same shape. You have Pink Bismuth, same colors, same shape. You have Walgreens Soothe, same colors, same shape. Now the question is, are these companies, are these generics infringing the Pepto-Bismol trademark using the same combination of colors, the same fonts, the same shapes? And the answer to that is no, they're not infringing, because the question is, remember, the test is there likelihood of confusion? And if you can see this on the Walgreens bottle, it specifically says compare to Pepto-Bismol. And by saying compare to Pepto-Bismol, it is specifically telling the consumer, don't confuse us with Pepto-Bismol. This is so prevalent that store brands, that some brands like Vicks specifically says we don't make the store brands. I want to show you one of the most famous examples of a potential trademark infringement, which is the Andy Warhol Campbell soup can. Now the question is this trademark infringement? This is exactly the same can. This is not parody. There is no difference in the colors. There's no difference in the shape. There's no difference in the font. Is this trademark infringement? And while you think about that, one of the anniversaries of this series of cans was a few years ago, and the general counsel of Swanson, which owns Campbell Soup now, was asked about this, and they had made the decision that yes, this was trademark infringement, that Andy Warhol was piggybacking on all the work that the Campbell Soup people had done to create this image, this logo, without paying the Campbell Soup Company anything. And so the general counsel, the legal department, went to the executive staff, the CEO of Campbell Soup, and said, we think we have a good case for trademark infringement. And the Campbell Soup higher-ups said, are you crazy? Why would we want to sue Warhol? Warhol has made our brand iconic. And so even though the legal people said this is absolutely trademark infringement, the business people said this is not harming our brand. It's not harming our brand the way the Disney people thought that Sky Pirates was harming the image of Disney. So they said they would not sue. There have been a couple of recent cases that have involved trademarks with respect to different types of artists. This first one is a case where Bad Spaniel Old Number 2 Tennessee Carpet. This is a dog's chew toy, which is made to look like a Jack Daniels bottle of Tennessee whiskey. And Jack Daniels, which had no sense of humor, decided to sue Bad Spaniels for trademark infringement. This is a case where the court said, no, this is an obvious parody. Nobody was going to be confused that even though the shape of the bottle is distinctive, and the court said that Jack Daniels could trademark the shape of that bottle, but that nobody would be confused that this chew toy that talked about dogs doing number 2 on a Tennessee carpet instead of Jack Daniels number 7 Tennessee whiskey was really from Jack Daniels. The Supreme Court was involved in a case involving an Asian American band called the Slants, who wanted to trademark their name and logo. And the Trademark and Patent Office refused to give them a trademark because the law creating the Trademark Office says that the Trademark Office can refuse to grant a trademark to any derogatory name or logo. And they said this was a derogatory name. And the court said the Trademark Office does not have the right to make a determination as to whether something is derogatory. The same, and of course, the Redskins were the next people in line about that. What ended up happening is that the market took over, and then the market decided that this was an offensive trademark. The Trademark Office did the same thing regarding a clothing manufacturer whose name was FUCT. And the Trademark Office said this was a scandalous name and we don't have to give them a trademark. The United States Supreme Court again said you can't do that. The Trademark Office does not have the right to make those determinations. Let the market decide. Now, why, again, do companies protect trademarks so much? Because if you don't protect your trademark, it can become diluted. And there are several famous brand names that everybody was used as a generic name and they lost their trademark. One of the most famous of those was aspirin, which was the trademark of the Bayer company, but everybody called those similar products aspirin. Bayer lost their trademark. Zipper used to be a trademark and they lost it. Now anybody can call what they make a zipper. Heroin was a trademark. I'm going to jump a little bit. and go to copyrights. Copyrights are part of the Constitution. The Constitution, Article 1, Section 8, Clause 8 specifically says that the Congress is given the power in order to promote science and useful arts, to secure authors and inventors exclusive rights to their writings and discoveries. Basics of copyright. Copyrights do not protect ideas. You cannot copyright an idea. You can copyright the expression of an idea. And registration is really easy. You go to the Copyright Office, which is run by the Library of Congress. They will walk you through what is it that you're trying to copyright. Is it a work of art? Is it a photograph? Is it a writing? Is it a recording? They will walk you through what you need to copyright. You don't need a lawyer to get a copyright. For infringement, the test of infringement on a copyright is access and similarity. Did the person alleged to have infringed the copyright, did they see the original work? Did they somehow have a chance to read the original work, look at the original picture? And then how close together is it? You know, this is the old thing about if you had an infinite number of monkeys and an infinite number of typewriters, one of them would type the complete works of Shakespeare. So in that situation, there might have been similarity, but there wasn't access. So you gotta have both things. A couple of copyright cases that specifically involve artists. Patrick Carew, who was a photographer, sued Richard Prince for taking his work of art and changing it by just doing some cutting and pasting. And Carew had spent years putting his photographs together, and all Richard Prince did was, you know, add a guitar, add some masks, and the court in that situation, this was a Court of Appeals in New York, said that Richard Prince had the right to do this without infringing the copyright because he had made his work transformative. There's a case currently pending in the United States Supreme Court involving the other Prince, Prince the musical artist, and the estate of the estate of Prince the musical artist is suing the estate of Andy Warhol, the Andy Warhol Foundation, for doing pretty much the same thing, taking photographs that were owned by Prince and changing them and going beyond the license they'd been given. The Court of Appeals in this case said that Andy Warhol had violated Prince's copyright, and the United States Supreme Court is looking at that right now. And finally, one other copyright thing that I want to show you that you may know about is this is a copyrighted picture from the Associated Press owned this copyright, and you may know the artist who changed this. You may know what this happened to. This became the iconic Pope poster. The AP sued Shepard Fairey on this. Now you might think that this is the same type of transformative fair use that would have worked in the Carew case. It never got to that point because Shepard Fairey ended up being indicted for destroying evidence. Shepard Fairey ended up lying under oath that he had seen the AP picture and then was found to be guilty of destroying the evidence that showed that he had had access to the AP picture. So he was sentenced to probation and fined. And it just really, to me, it was an act of cowardice because he really could have, I think he could have made a really good case that he had created an entirely new work of art, but he did not have the courage to do that and instead destroyed the evidence showing that he had access to the original work. I'm getting signals that it's time to stop for some questions, so I will stop there. There are other things that we should talk about moral rights sometime, I teach 2 courses at the Art Institute, one called Street Law for the Artist for undergrads, and I teach a course called Law, Politics, and the Arts in the grad program of the Arts Administration program, where we go into all this stuff in a lot of depth and look at some of the cases. And I'll open it up.
So we're open for Q&A. Any question about trademark, copyright, and where you can register for your work? Now it's like free to ask. As Michael said earlier, there's no you don't need a lawyer to register your work, get a certificate that you own this piece. And is there anyone have question on that, or yes?
What do you think in terms of the Warhol Prince case?
Hey, the question was, what do I think of the Warhol Prince case? I'm with the lower court on this. I'm looking at both artists, and you've got Patrick Carew, who spent his life taking these pictures, and then Richard Prince just takes and makes a couple of changes, and suddenly it's transformative, and he doesn't have the right. I don't like the idea that judges get to decide what's transformative, and so I'm with. I was with Patrick Carew on this. I'm with Richard. I'm with the Prince estate on this. I listened to if you're interested, the Supreme Court had oral arguments on this case just a couple of weeks ago. It's available on the Supreme Court website, and it's very interesting to hear about it. And the Chief Justice specifically said, so is something transformative just if you take a picture and you put a funny nose on it, does that make it transformative? So the Supreme Court is going to come out with a final decision on this. I hope that they go in favor of the original artist, who I think deserves royalties if somebody takes their picture and does something with it.
Do you think would that have a big ripple effect in the art world if they decide that Warhol did not transform the work?
I guess which part of the art world? The original artists, I think, it will help them. Certainly, photographic art, they were very strong about that their original work deserved getting royalties. Transformative art, it's going to be good to get a standard. And if the Supreme Court sets a standard on what's transformative, does it really change, or are you just piggybacking on the fame of the original? I think it's good for the arts world if that happens.
Sort of to jump off of what you were talking about how judges don't really know too much. Well, you're saying how you don't think a judge can determine something transformative. So do courts and I guess judges usually not have some sort of team that is more, I guess, involved in the arts to help them decide that?
Well, during the hearings and the trials on the question was to follow up on courts making decisions on what's transformative. Certainly during the trials on this, there will be expert witnesses on both sides. But ultimately, it's the judge who is saying whether or not it's transformative. And you wonder maybe, for patent cases, they have special patent courts where the judges are specifically studied in this and educated in those areas. If this becomes really a big deal, you might say, well, maybe we should be sending this to a separate group of judges who at least have the expertise that they can decide. They can listen to both expert witnesses on each side, and they can make a more educated determination.
Given the ease of registering an artwork or a piece of art under Creative Commons, do you think that that's like an effective solution for artists to?
Well, the question was about Creative Commons. Creative Commons recognizes copyright. It's not like the copyleft movement that says everything's free. What Creative Commons does, it says, I own this work, but I'm giving you a license to use it under certain situations. And what Creative Commons does is it acknowledges the copyright, but it says, we're not going to charge a lot of royalties. We're going to let you use it, but you still have to recognize that I own it. And I think that's a good thing. One of just the points of law about this is, under the law currently, once you create a work of art, you own it. You own the copyright. But in order to defend your ownership against somebody else who may have infringed it, you have to have registered the copyright with the Copyright Office. So you own it. You own the copyright as soon as you create the work, but you can't go to court and sue somebody for infringement unless you've previously registered the copyright.
So then, would you need to register a Creative Commons work with
With the Copyright Office, yeah, yes. And then simply under Creative Commons, you're licensing it to other people under these certain conditions of attribution. Next question.
I have a question about contracts. So you said that like a spoken contract wouldn't be valid, but like could you use text messages as like an agreement if there's no like, signature or contract?
It depends, which is I tell my class is the answer to 98% of the questions I get asked in class. It depends how clear the text messages are. A contract requires an offer and an acceptance and an agreement. And if you can prove through the written work that yes, this person did agree, and that you wrote an offer to them and they agreed to the same terms of the offer, but without a contract, I commission you to do a work, and I'm going to pay you $500. But in our exchange of text, have I said when I'm going to pay you? Have I said whether or not I'm going to pay you for any materials or expenses? Have I said, do I have a right of refusal? Without all of that stuff, that group of texts may not really be worth anything unless you can really prove that the offer matched the acceptance. Let me give somebody else a minute. Yeah.
If someone copies someone's work and it is infringement, but if they did not make any money off of it, and if they stopped when they were asked to, what are the bad things that can happen?
Yeah, the question was if somebody infringes your work but they don't make any money from it, should you have remedies? You still can, you can ask for money damages if you can show what you lost. But you can also require them to stop working, and you can require them to destroy the works that they've created if you can prove infringement. And I've been in situations like that where I had to provide on behalf of my client a certificate of destruction showing that I had destroyed the infringing pieces.
If you were to put a rough number at about how much, like, the value you should start, like, building a contract for work, like, is it worth it to have a contract at above a certain amount versus, like, the amount that you'd be spending on a lawyer to enforce it? Whereabout would you say is the break-even point?
I think it is always worthwhile to have a written contract, and contracts are not they're not scary things. Contracts say contract is between party A and party B, and party A promises to do this, party B promises to do that. I promise to paint your house, I promise to pay you $1,000. And you put it in writing, you put both names on it, and you sign it. And that's going to give you a lot of protection. And if you may have to do it in small claims court where you don't need a lawyer, or maybe if it's worth a lot, you do it in regular court where you have to pay a lawyer. But it is so easy just to write a contract and get the other side to sign what they're agreeing to do. I don't put a limit on it. I say just always put something in writing, and then you have the evidence. Yeah.
This is a sort of stupid question because I'm not familiar with contracts, but do those need to be like legally approved or anything like that in order for them to like be valid? If that makes
I'm sorry, say it a little louder, please.
For a contract to be like valid, does it need to be legally approved in any way?
No. The question was, does a contract have to be legally approved before it's valid? No, you don't need anybody else writing a contract. Just you and the other person set out what you're doing, put a date on it, and sign it. In some types of contracts, you need the signatures notarized, but in most cases, you don't need to notarize a signature, you don't need anybody else involved.
That was a good idea to have a lawyer look at a contract.
Oh, yeah, you know, if real money, the question is, you know, it's a good idea to look at a contract. If real money's involved, yeah, it's worth it. But if it's a simple commission to do a work or something like that, it's a sale, just put it in writing, both of you sign it, and you've got a legally binding document.
We're gonna have one last question because Michael have a class at 6 o'clock, so, yes.
If we're looking for a lawyer to look at our contract for like just one time, how would you recommend us to go and find a lawyer?
I would recommend you call Lawyers for the Creative Arts. Lawyers for the Creative Arts is an organization made up of lawyers. They contain a list of lawyers, and depending on your own assets, you can either get free legal assistance, or they can give you a list of lawyers who will give you reduced rate assistance. And these are lawyers who are specialized in helping artists, arts organizations. And that's the place I'd start with.
I think we can take one more question. Did you have
Oh yeah, just, you're selling work in a gallery, for some kind of show, and then the gallery gets a percentage and all that. In that instance, you wouldn't need a contract, right?
No, absolutely you do. And in fact,
Oh, okay.
because so many artists were exploited by gallery owners who were using the money they got when they sold your work, and instead of putting it aside for you, they were using it to pay their own rent. Lawyers for the Creative Arts got together with the Chicago Artists Coalition, and they passed a law called the Illinois Consignment of Art Act that specifically puts rules for gallery owners and artists. And in fact, it says in the law that the gallery owner has to put in writing certain terms. So yeah, don't, and it says that this is despite any pattern in practice. So if the gallery owner tells you, oh, we don't have to do that, the law specifically says that they have to.
So I think thank you so much, Michael, for this
I sincerely apologize for skipping your bio, so I'll read Michael's bio really fast. He's an election lawyer and adjunct professor at the School of the Art Institute, and he served as a special counsel to longtime Liberal Congressman Sid Yett, an experience which led to his co-authoring Clear It with Sid, a biography of Yett published by University of Illinois Press. He directed the creation of Chicago's first cultural plan during the administration of Harold Washington, and consulted during Rahm Emanuel's revisiting of the plan. His election law clients have been Barack Obama, Mayor Lloyd Lightfoot, new Secretary of State Alexi Giannoulias, Attorney General Kwame Raoul, Illinois Supreme Court Justice Liz Rochford, and many other federal, state, and local public officials and candidates. He has been a board member of Art Alliance Illinois, Illinois Humanities, and Lawyers for the Creative Arts. He recently served as general counsel to the Democratic Party of Illinois. Thank you.
For more information about the talk in the future, we will post on our Instagram account. Soman and I will post more section like this. We will invite Michael. He's still available in the future for continue the conversation. Follow Soma's art laws from artists.
And it's an art law magazine. I run to look at the art law cases from artist view. For instance, I just posted about the taped banana at the Art Basel 2019, and it's probably be going on the court case. So if anyone's interested, you can look at the Instagram. Thank you.
And Ask Gallery Contemporary is the off-site exhibition platform at the school. We host off-site opportunity for artists to show their artwork, and also we host art talk about the contract, about the copyright, and we partner with Sona in the future to host this event like this. feel free to DM us if you have any further question about the law or contract, trademark, copyright.
And we're not experts, we'll ask other experts and try to provide you information, and also please take the food.
Thank you so much, Michael.
Thank you.